Let me know when you're ready. You're ready. Okay. Let's go on the record. We have two cases with Mr. Spencer, positions 7 and 8, 26 SC 001266 and 22 SC 180 465. Good morning, Mr. Spencer.
Morning, sir.
Mr. Spencer is here with Ms. Rios as his lawyer. Ms. Smith is here for the state. Mr. Spencer, Ms. Rios tells me you are prepared to enter pleas in both of your cases. Is that correct?
Yes, Your Honor.
Okay. Ms. Smith will put you under oath in just a moment, ask you a series of questions about your rights and your cases. Please answer her questions truthfully and completely. It is just as important that you let me know if you have questions that need to be answered. Most of the time you'll be answering questions, but if there's something you don't understand or you're confused by something, or you just need to speak with Ms. Rios, you'll let me know?
Yes, sir.
Great. Ms. Smith.
Thank you, Judge. Mr. Spencer, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Aaron Michael McCreary Spencer.
Can you spell your second middle name?
It is my primary birth last name.
Okay, whatever one that is, spell it.
McCreery.
Thank you.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine.
Okay, what medications are those?
Remeron and Zyprexa.
Tell me for what diagnosis you take those medications.
Zyprexa is to battle my depression. I suffer from manic, depressive, and suicidal tendencies. And Remeron is to battle my sleep difficulties. I have difficulty sleeping.
Okay. When do you typically take the sleep medication?
I take the sleep medication at approximately 9 p.m. each night.
Did you get it last night?
Yes.
And the depression medication you take when?
I take that also at 9 at night.
Did you get it last night?
Yes, sir.
Do either of those medications have lasting effects such that the next morning, where we are now, you are left woozy, drowsy, confused?
No, sir.
You feel like you understand what we're doing?
Yes, sir.
Are you at this time, sorry, how old are you and how far have you gone in school?
My age is currently 34. I went to the 11th grade before finishing with my general education diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in both of these indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Spencer, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court? Is it?
Into 3.
Okay.
Do you guys need to confer?
Okay. I mean, you like a thousand days.
Well, actually more. He's been in for 3 years and 1 month on the most recent arrest. For the 22 SC case, he served a year before he was released, and he gets credit for this as well. So in connection with that case, he served 4 years and 1 month. So for the 26 SC case, 3 years. For the 22 SC case, 4 years.
All right. 4 years. All right. 4 years. 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 4 years Mr. Spencer, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 3 with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you also understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Spencer, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 22 SC 180465, how do you plead to count 1 aggravated battery?
Guilty.
As to indictment number 26 SC 001266, how do you plead to count 1 willful obstruction of law enforcement officers by use of threats or violence, count 2 riot in a penal institution, and count 3 simple battery?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Spencer. Your Honor, in this case, starting with the oldest indictment ending in 465, if this case were to proceed to trial, the state would show, or the facts would show, that on February 21st, 2020, officers with the Atlanta Police Department was dispatched to 22 14th Street regarding a battery case. When the officers got there, they spoke with the victim, Mr. John Wise, who stated that he was walking toward a establishment, or I believe some type of restaurant, when the arrestee, Mr. Spencer, in this case, punched him in the face. Mr. Wise advised that he did not know Mr. Spencer. They were not friends. They had not been together in the past or anything like that, and that he was a stranger to him. Mr. Wise advised the officers that he was crossing paths with Mr. Spencer when Mr. Spencer started moving and dancing awkwardly, and then out of nowhere just punched Mr. Wise in the face. Mr. Wise had a bleeding laceration along the swellings of his face. There was a witness on scene who told the officers kind of the same thing that Mr. Wise told the officers, that Mr. Spencer in this case just kind of came out of nowhere and punched Mr. Wise in the face. Mr. Wise was taken to Grady Hospital, where He was treated. He had lacerations on his face. His face was bloody. And I have some pictures of those that I spoke with Mr. Wise about showing today. But I think because he's taken the plea, we're okay with not showing those photos. I did get a chance to speak with Mr. Wise. He is on the call. He said that he would like to be on the call, but he doesn't want to make a statement. He was okay with basically summarizing what we've talked about, which is this was something that came out of nowhere, kind of has impacted his life. However, he is okay with the offer in this case and supports the plea that the defendant is doing today. Regarding the negotiated plea between state and defense, we've agreed to a sentence of 10 years to serve 3 with the balance probated. Regarding the special conditions of probation, like I stated earlier, the defendant and victim, they are strangers. However, we're asking for no contact with the victim in this case, just in case he sees him again. We're asking for the defendant to complete an anger management course and also a mental health evaluation with treatment if necessary, and alcohol and drug abuse evaluation with treatment if necessary. And that is all from the state.
All right. What about the other case?
That is correct, Judge. There's another case. Regarding the facts and circumstances of the indictment ending in 266, the facts would show that on February 18th, 2025, the defendant in this case was housed at the Fulton County Jail. And he got into a physical altercation with the detention officer, Tony Cook, and also an inmate, Centrice Reed. There was an initial physical altercation between inmate Reed and the defendant in this case, where the defendant punched Mr. Reed in the face. Detention officer Tony Cook came to break up that fight. And when he came to break up the fight, the defendant in this case, as is reported, punched Mr. Reed and bit him on the left arm. At this time, the defendant was tased and he was detained for this assault on the inmate and on the detention officer. Both of these cases happened in Fulton County, but those are the facts and circumstances of 266.
Got it. Thank you. Let me look one thing up. Okay. Criminal history information.
2024 aggravated trespass conviction. 2022 battery conviction. That's 2018 arrest for felony obstruction. 2015 assault battery.
Out of what? Out of state. Okay, thank you. Ms. Smith, there is a recidivist notice in the 22 SC case. Are you waiving that for purposes of, it's sort of moot given what the sentence is, but we just need to have the record clear. Either you're enforcing it or you're waiving it. Waiving it. Okay. All right. Ms. Rios, tell me a little bit about Mr. Spencer. Looks like a complicated situation. He was in jail for 3 years. Not on either of these cases. One of these cases occurred after he'd been in for 2 years, but it was the case with Judge Cox where he ultimately pled to time served for biting a piece of someone's ear off.
Yeah.
So what's going on?
He suffered with alcohol addiction for a while. We've talked and since he's been in jail for 3 years, hasn't had access to alcohol. And he says that doesn't think he needs any assistance, that he's be good. He's been sober for 3 years and he thinks he'll have a handle on his life when he is released. He's 34 years old. He's originally from Detroit, but lived in Atlanta for the last 8 or 9 years. He moved here, said because of the weather and just for new opportunities. He does not have any children. He did complete his GED and he does have some experience in landscaping work. So when he gets out, he's going to try to get a job doing that. He can go back to Atlanta Rescue Mission. He'll go there to get on his feet. We did do a referral to PAD, but they did not accept him due to the charges.
Okay.
So I just ask that you accept the plea as negotiated and waive probation fees for 6 months, but if not inclined to 6 months, at least 3 months.
Okay. Mr. Spencer, I've got a couple questions for you, and then if there's anything you want to add, I'm happy to hear from you. I think Ms. Rios answered one of my questions, which is you don't have a place to stay when you get out. You don't have family here or friends where it would be safe for you to stay, so you're prepared to start out at a shelter?
Yes, I stay predominantly when on the outside world at the Atlanta Rescue Mission or at the outreach program located on 3rd Street.
Okay, so you have an idea of where to go.
Yes, sir.
Okay. All right. Do you have family back in Detroit?
Yes, yes.
Okay. Are they a resource for you, or that's not really a connection you have anymore?
They would help me, but they've helped me so much in the past that I feel bad asking them for help.
Okay. All right. Mr. Wise, who is the victim in this case from long ago, 2020, but obviously it meant something pretty serious to him because he's taken time out of his day today, 6.5 years later, to listen to the proceedings. A stranger to you?
Yes. Yes, sir.
Okay. And when this incident happened, was it a psychotic episode? Was it an addiction-related episode, or a combination of the two?
Neither. That day, as stated, it was very, very hot. I'm from Detroit, which hot is during the winter, it gets, is about 12 degrees. And so this particular winter day, it was 90 degrees. And so I was suffering from heat stress. And I was trying to ask him for help, but I was intensely impacted by the heat. And so instead of being able to ask him if he would buy me a soda, I just freaked out and swung at him whilst in the middle of asking him for spare change.
Okay. And then the situation with the case you had with Judge Cox, the ear, a stranger to you or someone you knew?
A stranger, Your Honor.
Okay. All right. Well, Mr. Spencer, I hope that you avail yourself of some of the supports that are out there. I think that the evaluations that you're going to get may lead to some good recommendations for treatment. You are going to need to work hard to reconnect with medication support. The sheriff's office has unfortunately greatly reduced the size of the supply of medication that I can require them to give you when you leave. And you take medication for important reasons, helping you sleep, helping you manage manic depressive situations. And I don't know that you're going to get a very large supply of that. And then you will have no medication when that runs out. The sheriff may rethink this policy because that will result in some people going right back to jail, which is what we call cutting off your nose to spite your face. But I hope you have resources in place, and maybe one of the shelters where you stay, they can connect you with Mercy Care or Grady or whatnot, and you'll be able to re-up the meds. But they are important because in my experience, people who struggle with what you struggle with, if they can't get prescription medication, they find other ways to feel better. And those aren't always legal, and then they lead to complications, and your ice is very thin. You'll be on probation, but the next judge to get your case, if you have another case, is going to look at what you've been doing and been through, and you're going to get locked up again for a long time. So I encourage you, one, to take advantage of the resources that are out there, and two, make it one of your top missions to get back on medication. And I wish I could get you a larger supply, but there is a recent change, and you may leave with as few as 4-day supply of medication. I could not refill a prescription in 4 days if I wanted to, because I'd have to get my doctor to mail something in or phone it in, and then I get to, and I got all sorts of resources that you don't. So I'm worried about that piece. And that's not your fault that you're leaving with a 4-day supply of generic medications that probably cost $10, but that's not a decision that I get to make right now. So here's what we're going to do. I find there's a factual basis for both your pleas. And I find that both your pleas are knowing and voluntary, meaning you've understood what we talked about. Fair? Yes?
Yes, yes.
And voluntary, no one's forcing you to enter these pleas. Also, you agree with that?
Yes, Your Honor.
Okay. So I'm accepting your pleas. And I want to confirm, Mr. Wise, that there's nothing you want to add. I know you're on the call. I'm not calling you out, but Ms. Smith relayed to me that you were good to go, simply observing what's going on. I just need you to confirm that I'm not preventing you from giving an impact statement. All right, I'll take that silence as he's good to go. Ms. Rios, do you authorize someone in my office to sign both indictments on your behalf as well as Mr. Spencer's behalf?
Yes, sir.
Ms. Smith, can someone in my office sign both indictments for you? Okay. Mr. Spencer, in 26 SC 001266, your sentence on count 1 is 1 year to serve, count 2 is 1 year to serve, and count 3 is 12 months to serve. Those will all run concurrently with each other, and you will get credit from February 26, 2025. We gave you some bad math earlier when we said, hey, you've been in for 3 years, you get credit for 3 years. You can't get credit for time you served before the incident. And you're getting into it with Detention Officer Cook and Inmate Reed. Didn't happen until February of last year. You certainly get credit for every day since then, and that's been more than a year. So a year to serve basically on that case. In 22 SC 180465, that's the case in which Mr. Wise is the victim. It's 1 count, and your sentence in that case is 10 years to serve 4 years with the balance on probation. You'll get credit for the time you served in connection with that case, which is in 2 pieces. There was a year to serve originally until you made bond, and there's been an additional 3 years plus since you were last taken into custody, and that was in connection with the ear case. So 10 years to serve 4 years, balance on probation. Special condition of probation number 1, probably the most important one, is you leave Mr. Wise alone.
Yes.
He's a stranger, that should be the easiest condition, but don't use social media to try to track him down to say, I'm sorry, or you should have bought me a soda, or whatever. He goes his way, and hopefully today is the last day he needs to think about these proceedings. Special condition number 2 is that you submit to a mental health evaluation, and that's for you to get with a medical professional, likely at Grady, and that professional will work with you to say, what's the right regimen? Is it medication? Is it counseling? Is it what? But whatever treatment that professional recommends becomes a condition of your probation. So if that professional says you need to take Zyprexa, that's not optional for you. You take that as a condition of probation. You will also have a drug and alcohol abuse evaluation. And again, if there's treatment recommended, that treatment becomes part of your probation. Go to an NA meeting or a this or a that. That'll be something you'll need to do as part of probation. I will waive your probation supervision fees for the first 3 months of probation while you are getting settled. And then if you are not working at least 10 hours a week by the end of 3 months of probation, then you're going to have 10 hours of community service each week. So we'll get you engaged one way or the other. If you land a job, landscaping, whatever it is, needs to be at least 10 hours a week. And if it is, then there's no community service. But after those first 3 months of probation are up, for each week you're not working 10 hours, then it will be 10 hours of community service, so that you are having some engagement other than whatever else is going on in your life. All right?
Yes, sir.
Questions about that?
Only one. So does that mean that I have a year remaining to sit in jail?
No, sir. You served 1 year on the case involving Mr. Wise before you were released. You get credit for that. You have since been in for another 3 years and 1 month. And statutorily, you get credit for that, even though you were in for something completely different. That is custodial time subsequent to the offense you're pleading guilty to. The offense you're pleading guilty to is the aggravated battery on Mr. Wise. And so you served 4 years for that, and no one can ignore that. And people shouldn't look at this saying, he got a time served sentence. You didn't. You got a sentence of 10 years to serve 4 years. And unlike many people who get a 10 to serve 4, you served every day of the 4 years. If you had received a 10 to serve 4 sentence 1 month after you did what you did to Mr. Wise, you would have been out of the prison system within a year. You would have served probably a third of your sentence. Here, you served every day plus a bonus month of the 4 years of your sentence. But you will be released. I can't promise it would be today, but it ought to be this week because you've served the 4 years.
Thank you so very much, Your Honor.
Ms. Rios, anything else on behalf of Mr. Spencer?
No, thank you.
Ms. Smith?
I think we're okay.
Okay. Thank you, everyone.